Any mention?
Please, Your Lordship. Lordship, I beg to mention item number 16, my lord. Item may kindly be adjourned for a week, my lord.
Yes.
Lord, I have no objection.
No objection, Your Lordship.
When do you want it?
Next week, my lord, if possible.
After 2 weeks.
1 week.
One.
After 1 week.
Much obliged.
On behalf of the petitioner, list of. Yes.
Much obliged.
May I please, Your Lordship, I beg to mention item number 3. Your Lordship, I'm praying for 4 weeks' time, Your Lordship.
There is the same matter which is pending before division
Yes.
bench. What happened to that? The collector matter,
It's coming up on the 27, Your Lordship.
when do you want it? Who is the other side here?
4 weeks.
There is no one for the state.
Number 3.
Yes, sir.
Yes.
I have no objection, Your Honor.
What is the matter about?
My lord, this relates to the coal, my lord, in that. A division bench matter pertaining to that coal is also connected.
What is the position of the division bench matter?
My lord, I don't have the latest instruction on that.
This also 2 weeks on the prayer. 2 weeks.
4 weeks, Your Lordship.
Why 4 weeks? Okay. We'll adjourn for 4 weeks. Yes. Number 3, 4 weeks. Yes.
Much obliged. May I please, Your Lordship, I beg to mention item number 5.
No objections, Your Lordship.
I pray for 2 weeks' time, Your Lordship.
Yes.
Much obliged.
Your Lordship, I beg to mention item number 17, Your Lordship. I'm praying for a week's time, Your Lordship.
You are appearing for?
State respondent, Your
I
Lordship.
have no objection, Your Lordship.
What is the matter about?
It's quashing of the affair.
After 1 week.
After 1 week, Your Lordship.
After 1 week. 17 on the prayer of the.
Obliged, Your Lordship.
Yes.
Obliged.
May I please, Lordship? Lordship, I beg to mention item 18. Praying for 2 weeks' time, Lordship.
Your Lordship, I'm from respondent number 2.
Any objection?
Pardon, Your Lordship?
Any objection?
No, Your Lordship.
2 weeks. 18. 18 also 2 weeks on the prayer of the. Yes.
Obliged.
Much.
Item number 1.
Yes, Mr. Kalinda.
Lords, I'm appearing in item number 1 for the petitioner.
Yes.
My lords, this is a matter where order of discharge has been challenged under section 482 CRPC 528 BNSS. My lords had put a question before me last time, wherein my lords had asked me to produce judgment whether it is maintainable under section 482 CRPC and not under revision. For that, my lords, I would like to place a case law. My learned friend would hand it over. Vijay and another versus State of Maharashtra.
It's a decision by Apex Court.
Apex Court, my lords. My lords, this is a 2017 case.
Yes.
If you will come to para number 5,
Yes.
if I may be allowed to read, my lords.
Yes.
It says a scrutiny of the order of the High Court reveals that the whole basis for the High Court to pass the order impugned is that there is an alternate remedy available to the petitioner, that is by way of revision under section so and so. Hence, the jurisdiction under section 482 CRPC cannot be exercised
This
by
is a revision
indirect.
under 156 up close 3 mean. There is
156, my lords, but later when we'll come to para 6 and 7, he has discussed this.
Okay. Okay.
Hence, the High Court disposed of the application, reserving the liberty to the appellants to take appropriate steps as are available in law, and further directed to complete the investigation within 3 months from the date of the order. Para 6. The learned counsel appearing for the appellants relied upon the judgment of this court in Dhariwal Tobacco Products Limited versus State of Maharashtra. Only because a revision petition is maintainable, the same by itself, in our considered opinion, would not constitute a bar for entertaining an application under Section 482 of the Code, even where a revision application is barred, as for example, the remedy by way of Section 115 of the Code of CPC. This court has held that the remedies under 226 article of the Constitution would be available. My lords, next para is important. The learned counsel further relied upon a recent judgment of this court in Prabhu
Now,
Chawla
this
versus
is
State
one
of
thing,
Rajasthan.
this code, will you not know, this is reference, it speaks about 482 of the code, then again it speaks about revision under 115. 115 is civil revision, isn't it?
I
Yes.
agree, my lords, but if you look at para 7, I'll just read para 7, that talks about 397 CRPC section.
Yes.
Para 7. After hearing the counsel and also after perusing the impugned order, we are of the considered opinion that the order of the High Court has no legs to stand in view of the law laid down by this court in Prabhu Chawla. In the above referred case, in view of the divergent opinions of this court in Dhariwal Tobacco Products Limited and Mohit versus State of UP, the matter was placed before the three-judge bench of this court. The three judges bench took the view that Section 482 CRPC begins with a non-obstinate clause to state 482 has been defined, my lords. Next para. As Section 397 CRPC is attracted against all orders other than interlocutory, a contrary view would limit the availability of inherent powers under Section 482 CRPC only to petty interlocutory orders, a situation which is wholly unwarranted and undesirable. The three-judge bench has confirmed the law laid down by this court in Dhariwala Tobacco Products Limited. My lords, para 8. In view of the above settled law, mere availability of alternate remedy cannot be a ground to disentitle the relief under Section 482 CRPC. And apart from this, we feel that learned judge, my lords, that's on the merit of the present matter.
So that means now 482 is an alternative of
Yes,
397.
it is. It is. My lords, we have one more judgment if we look at Prabhu Chawla.
No, it's
This
okay.
is a
Prabhu
three.
Chawla is a three-judge bench headed by
Yes,
Justice
yes.
Bhavai, probably, isn't
Yes.
it?
Yes, my lords.
Yes. All right. All right, boss, it will do. Yes.
Lordship, may kindly allow us to seek instructions, Lordship. Kindly allow us to seek instructions, Lordship.
No, we'll issue notice. You take it.
My
We are
lords,
issuing
then
notice.
if stay, because the charges will be framed against the petitioners, that will be
No,
a
but then
problem, my
stay.
lord.
You have to then go for hearing, madam.
I will come to the merit if at all, if
No,
that's
definitely.
the.
We without hearing, we cannot grant any stay. We have to
Yes,
see
yes.
what is
So
what
if
are the.
can I proceed then on merit, my
Yes,
lords?
where is your senior?
Lordship, he's on legs before courtroom number 2, Lordship.
So when he will be available?
Lordship, if we can have the matter at the end of the board, Lordship.
At the end of the board. So we do not know how long this court will continue. Then we'll see. We'll just see. We'll keep it for the end of the board. Says.
All right, my lords.
Item number 2.
May it please your lordship.
Yes.
Lordship, I am enter appearance today on behalf of the respondent.
Okay. There is only one respondent?
Yes, your lordship.
Yes.
Lordship,
Then what is it?
I appeared 2 weeks time to file objection to the miss case.
This is a revision, civil revision. What objection is needed? It is needed. They should file a written objection.
Yes, your lordship.
Not needed. What law permits you to file objection, written objection on a CRP?
To the miss case, your lordship.
To the miss case?
Yes, your lordship.
Yeah, to this case.
Okay. Just in say.
Lordship, interim to continue.
Wait. CRP, you just say, Miss E. Dahar, learned counsel, has entered appearance on behalf of the sole respondent. This is the main case, okay? Has entered appearance as the sole respondent. And how long will it take?
2 weeks, your lordship.
And please for grant of some time to obtain the necessary instruction. Prayer allowed, list after 2 weeks. Then come to the miss case. On prayer made by MS Idahar. Is there separate order sheet in the miss case? Where is the okay, just come now. Okay, Miss Idahar, Learned Counsel, appearing for the respondent. Prays for grant of some time for filing objection. Prayer allowed. List after 2 weeks. The interim order passed earlier shall continue till the returnable date.
Much obliged.
Hearing item number 4.
Yes.
Lordship, learned senior is on Lex, Lordship, before courtroom number 2.
This is 2024 matter.
Lordship.
Okay, you take it after some time. There may be a change in the roster. If in case we cannot finish the hearing also, we pass it over this bench, the things may change. There is an indication made. So I have it after maybe
Today?
1 2 weeks.
After 2 weeks?
It's up to you. See, what this court is saying, there may be a change in the roster.
Yes, you're right.
Okay, so this is a revision application of 2024. Okay, if any change is affected, then it might go before, land up before any other court also. So that is why. Just wait for the timing and just see which way things go. If parties do not have any urgency, and if you have urgency,
Urgency in the sense, Your Lordship, I am the decree holder. The award is passed way back in 2019 award.
then yes.
And after that, they filed section 34 and they never pursued for challenging the award. That was dismissed for default, and for 2 years they were sitting idle. They never pursued the matter. Meanwhile, we filed execution. Executing court passed order for executing the decree in the award. And there was an order to deposit the money. At that stage, they filed for restoration after 2 years, for restoration of the, with condonation petition for restoration of the appeal. Okay, appeal was restored.
Restoration of 34 application.
34 application. There was no stay, but no stay. Even in the execution, they never prayed for any stay. And in the appeal, is just simply restored. And Your Lordship knows mere admission of appeal doesn't amount to stay. They never pressed for any stay, and they are not even coming forward to hear on merit the appeal. They are not taking any active step to dispose the appeal on merit.
Get it dismissed.
Now, Your Lordship, appeal is pending for hearing. Meanwhile, the court has allowed us to withdraw the money. On their objections,
But a deposit was made.
deposit was made.
But then there is no stay given.
There is no stay. So we have the right
that
to
is
withdraw the money.
Unconditional deposit. It is not that the deposit on the is made.
But subsequently, when they
For
objected, yes, my lord, when they objected on withdrawal of the money, they filed objection that we should not be allowed to withdraw the money. Court allowed us to withdraw after hearing both the parties that they said ki we must produce bank guarantee. Bank guarantee has to be given. They were pressing for that. Then court, after hearing, said to balance both the parties, because it is a discretionary power of the court. And there are a number of judgments of the Supreme Court also that it is a discretionary power of the court, and if court allows security, it can be bank guarantee, it can be in any other form of indemnity bond or personal guarantee also will be sufficient. So court directed that for 50% of the amount you give bank guarantee and for 50% indemnity bond.
But then deposit was made for the whole amount or it's a part?
Whole amount was deposited, and a very mega amount, only 19 lakhs. Your Lordship. Only 19 lakhs. That also court, to do justice, said only for 50% you give bank guarantee and for 50% you give indemnity bond. So we were allowed, against that order they have come before this court. First of all, Your Lordship,
No, but then what difference it makes if 50% in indemnity bond and 50% in bank guarantee?
because and bank guarantee.
If you are successful, then they will refund back the money.
Yes,
That
my
is
lord.
That is what the law is.
And the same department, Your Lordship, on earlier occasions, in the same case where the same lawyer has appeared, I have appeared, the counsel for the other side also appeared, those awards were in crores. In crores, for more than 4, 5, 6 crores. Those were also allowed to be withdrawn only on indemnity bond.
But what you are trying to indicate?
No, I mean, such a for big amount, they did not object.
Which way you take your submission?
I'm not indicating, but I'm only saying, Your Lordship, what is better on record. For 6, 7 crores award, they never objected and we were allowed to withdraw on indemnity bond. Here, only award of 19 lakhs, that also 50% bank guarantee, 50%.
What should be the security? Is it not the discretion?
For that,
of the,
this is pending.
Is it not the discretion of the court? Is it for you to say? Can you go and say that before the commercial court that no, that should be the security? It is for the court to determine. Condition is imposed by the court, isn't it?
And Your Lordship, this matter was referred to local lot. My party came all the way from Nagaland. He appeared. I was told that even department there were 2 departments involved, Assam Rifles and NPCC. Their officers were also having no objection. But still, somehow, because adjournment was asked for, the
Maybe all are not happy with you.
council was not present.
So
It
anyway,
did not.
we'll,
And this revision is also otherwise not maintainable, my lord. But I have been deprived of using that money.
you have it 2 weeks. See. Oh, it was referred to mediation also.
Yes.
Here also. Not settled there.
I have a latest case of Honorable Supreme Court, Your Lordship. There, this Honorable Supreme Court allowed to withdraw on personal bond, not even indemnity bond. On personal bond, the amount was allowed to
But
be
then
withdrawn.
which way they have? How much right they have to?
They do not have any right.
Is
It is a
it not the satisfaction of the court?
yes, it is totally discretionary power of the court.
Anyway, see, like it has returned from this mediation where it has failed. So we'll record it and list it for hearing. Okay. The matter was sent to the Special Mediation Committee. For enabling the parties to settle the matter amicably. Stop. However, it appears from the report dated 15/9/2025 of the report dated 15 September 2025 that no settlement could be arrived between the parties. Stop. Hence, matter request to be heard on merit. Stop. Let's pray for the parties.
Next week only, my lord.
Next week may not be possible. It will go first week, probably in the first week of November. Next week, see, we will not have the whole week, first of all.
Yes.
Second of, there is likely to be a program here on 25th or 26th of National Judicial Academy. So, there may be administrative occupation. We do not know, uncertain.
I have been deprived of you.
You see, you have waited for so long, it is 2024 matter, so just wait for another 2 weeks. After 2 weeks, let's pray for the parties. Yes.
Item number 6.
May I please, Your Lordship? Learned conducting counsel is on his legs in court number 2. So, hence my prayer before Your Lordship to take up this matter at the end of the board.
We have already matter for end of the board.
Come after some other day, Your Lordship.
After 1 week.
Some other day then.
Prayer met with the parties, list after 1 week.
Lordship.
We'll have it after.
Yes, yes, Your Lordship. Much obliged.
Second call. Item number 1.
Yes, where is Dr. Mojiga?
Lordship, my colleague has just gone to inform him.
When this case is coming up next again before the trial court?
It's on 5th,
19th of November, my lords.
19 November.
Can you have it next week after the Diwali break? Any day, say like
Yes, my lord.
22nd, 23rd, 24th. Will it be all right, madam, for you?
Yes, my lords,
Dr.
24th
Mojiga is
will
not
be-
available till now.
No problem, my lords. 24th, if at all my lords is available, then we will
24th.
have it.
Lordship,
Tell your senior and we will not accommodate him anymore if he's not there on 24th. On prayer made by the parties. On prayer made on behalf of Dr. Mojiga. He appears as DSGA, isn't it?
Lordship.
Not a DSGA appearing for the respondent. This is a matter on 24th. Yes.
Much obliged.
Much obliged.
Nothing more.